Good morning, Mr. Law. Good morning, Ms. van der Heever. Good morning, Mr. Matlala.
Good morning, Chairperson. Good morning, Commissioner.
Please pull the mics closer to you and switch both of them on.
Morning, Chair, and morning, Commissioners.
I greeted you and your mic was off. Good morning.
Good morning once again, Commissioner.
Thank you.
Thank you, Chair. Chair, Commissioners, you'll recall that Mr. Matlala had been subpoenaed to appear on the 7th of July, 2026. And on that date, Mr. Matlala's legal representative and I presented ourselves before you, and we had an engagement, the outcome of which was that Mr. Matlala's appearance was postponed to the 15th of July. Today, and the commissioners issued a ruling in that regard and on some other aspects. Mr. Matlala is present. We are back before you, and Mr. Matlala's legal representatives would like to address you, Chair. The issue about which she is about to address you is contained in the folders that have been made available to you, but I will leave it to her to take the commissioners through the contents of that folder. Thank you.
Ms. van der Heever.
Good morning, Chairperson, Commissioners. We have prepared for your benefit and in support of our application for a postponement an affidavit that was duly deposed to by our client. Due to time constraints, however, we were only able to last night email an unsigned copy to my learned friend. The situation was that for a variety of reasons this could not be done earlier. I would like to very briefly, if it's necessary, Chairperson, Commissioners, just take you through our reasoning as to why we respectfully submit that a postponement in this matter should be granted.
Is there a signed affidavit now?
There's indeed a signed. It was commissioned this morning, and we thank the commissions, my learned friend and her team, for assisting us with that. Even at, I think, at 10 o'clock, there was another endeavor made to get it signed at the prison. There were some arrangements, but it just came to no fruition.
I do see it in a small folder in front of me. I read from my laptop, and that was an unsigned version. Thank you, thank you.
Chairperson, in short, we set out the history of what's transpired vis-a-vis Mr. Matlala, when he was arrested, how the events surrounding him has unfolded. And the most important aspect thereof is the fact that he's due to commence with a trial on Monday. We believe that he's got the constitutional right to attend this trial and be regarded as innocent until proven guilty, together with the other constitutional rights that we've dealt with in this particular affidavit. We respectfully submit that for him to deal with some of the issues, which issues play a very big part in the up-and-coming trial that starts in 4 days, would violate his constitutional right to actually challenge the evidence. We've indicated to you, for instance, that both witness C and Lieutenant General Vusimuzi relied on a statement that was given to them by Mr. Matlala.
Before you get to that point, let me ask a general question. Is the submission that a person required to appear before a commission, but who also happens to be facing criminal charges, can never ever testify before a commission prior to the finalization of the criminal proceedings.
May I please, my respectful submission is, if I read, I've quoted for you from Justice Jafta's decision in the Zuma matter, and it's quite...
That was a minority judgment.
Yes, but still, I would respectfully submit, with the greatest of respect, Chairperson, that where you have constitutional rights, that those constitutional rights, especially in the very unique situation that my
You see, I'm raising the point that that was a minority judgment to understand on what basis you can then rely on that dictum or on that legal statement to suggest, in response to my general question, to suggest that a person who is facing criminal charges can never ever testify before a commission of inquiry.
I respectfully submit that when you have a person that's either an accused or a suspect, I respectfully submit that your constitutional rights, with the greatest of respect, override the compulsion that there would be from the commission side for him to give evidence. He would literally forego a large number of his rights if he is compelled to give evidence under those circumstances. I think what we've done, if you would just permit me, please, Chairperson, I think...
No, I just moved my shoulder.
Yeah.
I did not say anything.
No. I think respectfully, what I've endeavored to show to you...
You know what we always say in the legal profession, both amongst legal practitioners and people presiding, that when counsel says respectfully, they actually mean the opposite.
I was told that many years ago by a good friend that presided over a trial where he said, that was the impression. But I
sorry for interrupting you. Sorry. Yes, please.
I fully understand.
Yes.
The point is that is the nearest that we could come to any authority on this point. And this issue to us was so important that we were going to try and see if we could actually deal with this matter, if necessary, elsewhere. Where we are right now, I respectfully submit we don't have to go there.
Where is elsewhere? Is it a court application?
Yes. No, only the approach would have been to actually make, if the matter were to continue, to make the necessary full-blown legal argument and submissions to you, and then depending on your findings to take it on review. I'm honest, I've indicated that to my learned friend before too. It's because we so strongly believe that your constitutional rights, where the Constitution is the most important document in this country, those rights cannot be taken away from you by a commission who's got a certain mandate and who's, to quote my learned friend, on a fact-finding exercise. And more so, I think what we've done, Chairperson, we tried to set out to you why we believe that the constitutional rights, especially in this case, overrides what, and we're not fighting with what our client is duty bound to come and do at the commission. What we say is, so far you've heard one side of the coin. This side of the coin that you heard, and you see, don't want to go into the details. As we said, we don't want to give away our litigation privilege in that regard. If we run our trial, we will show to you that what you've heard potentially is either not the truth or unlawfully obtained, etc. And for that reason, we will, at the end, of course, also assist the Commission in finding the truth in this, what I respectfully say is a quagmire of facts that you have to deal with. That is the one issue.
Or may I, before you go to the next issue,
be presented piecemeal. I've said to you, Chairperson, and I stand by it, the only things that he can say to you at this point, I don't know A, B, C, D, and E. The rest of the issues we cannot deal with. And I, with the great greatest of respect, do not think it would be in your interest for him to sit here and say, I don't know this person, I don't know this person, I don't know this person. That's the only issues that we can form common cause on that he can at this point answer. We are trying to come to the Commission and answer what we can. The problem is, and I'm sorry to repeat myself, I can only do so if I know what he can answer is shown to me in black and white. I am trying to ensure that my client comes to this commission and gives evidence to you that is to your benefit, i.e. the work of the commission, and not for him to be to answer things that we as legal officers, and you've been in our position before, you can never allow a client to go on oath if you as the lawyer are not sure what he said there is right. I will not perform my duty as an officer of the court if I allow that. And for that reason, right now, I can claim privilege clearly on certain issues. I can say, this is my Section 35 issues. The others, I say to you, I can't at this stage because I don't know what's going on in the background. So it might even be, once I've got the documents that I think is necessary for me to decide it, that we can move on that. But right now, we can't. And I respectfully submit that based on the remainder of the issues that we've put here, that this commission should allow him the opportunity to finish the trial. And more so...
Again, please tell me when you are done responding to my question.
And then the last thing is, I think the thing that concerns me the most is, and we've taken the liberty of sharing a privileged document with you pertaining to the opinion. The one
I think that's something else then. Can I come in? Yeah.
And when that for me personally is very concerning at this point in time.
When you referred to a piecemeal hearing, this is just for clarity, does that mean you are going back on the earlier acceptance of what I posited to you, which was, is it something that can be done for this commission to entertain proceedings that relate to issues that have nothing to do with Section 35? And I understood you to be saying yes. But now, towards the end of your submissions, you said, I don't know, I'm paraphrasing, I'm not sure of the exact words you used, but you said something like it wouldn't be desirable to have a piecemeal hearing, something like that.
Yes.
Is that going back on what you said earlier, which was to agree with what I posited to you?
Yes. As I said, and the reason why I say piecemeal is all that will happen at the end of the day, Chairperson, is he will sit here and say, I confirm I don't know these people. And that is literally all we can do at this point. That is the only part of the Regulation 10.6 that we are at idem with each other. I say nothing prevents him from going under oath and say, I don't know person A, B, C, D, E, and F, and sit back. The rest of the issues, again, I want to emphasize, we want to cooperate. We've put it in our paper. But give us an opportunity to ensure that what we come to the Commission with is truthful. It's based on facts.
Another thing which arises from what you said in the context of the plea deal, and if I understood you correctly, you said this in the context of dealing with why a statement was not prepared. And again, if I understood you correctly, you made the point that you or your client had to wait until that plea deal process had been finalized so as to know whatever it is that related to the facts eventually. Here's a difficulty I have. Surely facts cannot change. Facts are facts. And I do not quite get it why Mr. Matlala could not have made his statement. He knows what the facts are, regardless of what the outcome of the plea deal were to be. he knew the facts, and therefore, from where I'm sitting, subject to your response, he could have said, these are the facts, and here are my responses to the notices that I have received.
Chairperson, the situation is
Or just to finalize, the facts could not be this or that, depending on the outcome of the plea deal. The facts are facts.
No, it is different because when people enter into plea deals, there's certain consensus reached and it goes, it's dealt with in totally different way, 105As, than what would normally, as you say, admit certain facts. If you go on a 220 or 115A and you admit facts, it's a different story. A plea deal goes beyond it. So very often there's facts behind it. As long as that 105A stood there and the magistrate has not ruled on it, our submission is that the issues there, he could not entertain his Section 35 rights on those. He could not come to the Commission and say, listen, I'm a suspect or an accused on this particular matter, and therefore I invoke my right to silence. It's a live process, and that live process has many complex issues behind it. So for that reason alone, he could not depose to that, to any affidavit here. I understand what you're saying, Chairperson. I understand what you're saying. But if he were to honestly depose at that point before Monday to an affidavit, he had to answer questions that we believe, because of him assailing from the 105A, he now has the right to invoke a right of a constitutional right.
But the Commission's interest would be facts in accordance with what Mr. Matlala knows, and that has nothing to do with whatever it may be that informed what he said for purposes of concluding the plea deal. So on that basis, I do not follow your response.
I stand by my response, Chairperson. I cannot, again, as an officer of the court, make my client say I invoke my right here and there and whatever, when I know in law the situation is that is a life process and he cannot invoke that right at that point in time. The facts, with the greatest of respect, you say that you have to answer facts, but facts have context and facts have background. You might see something as a fact because you've got a General Mkonazi that comes and says, oh, he said A, B, and C. I come back and I can't exercise that constitutional right before you say, whatever General Mkonazi said, he got out because the client was forced unlawfully and unconstitutionally to answer questions. He was not allowed, for instance, to have access to a lawyer. He was questioned for over 6 hours without food, etc. That surely influences that fact. Then it becomes no more a fact that we can rely on. It becomes a fact. And we know you are dealing with it as a fact because it's part of the process here. But it's a fact that was obtained unlawfully. And we have the right to make sure that you also know down the line that the facts that you rely on, General Mkonazi, for instance, say so, are not lawfully obtained facts. I can't come here and I'll say, please call so-and-so, put him in the box so I can challenge him as to how these facts that everybody now relies on were obtained. I can do that, however, because it's part and parcel of my trial that's starting on Monday.
It's exactly because there are those allegations, not only by General Mkonazi, but by many others, that the Commission wants to hear from Mr. Matlala, get his and underline his facts. You emphasize facts coming from General Mkonazi, and I add him and others. You emphasize those facts. What the Commission is interested now is facts from Mr. Matlala. But anyway, unless you want to comment on that, Commissioner Baloyi wants to ask a question.
Chairperson, as I said, those facts are facts that General Mkonazi rely on, that he says he obtained from my client. And we say what he relies on, you should not accept, and we can show you in due course why you shouldn't.
We've not
It's just
accepted
one
anything.
example.
We've not accepted anything at
No,
this
but I'm
stage.
saying to you, it's just one example. If I can, unless you want to hear me.
Commissioner Baloyi has a question.
I just want to make sure that I understand what you're saying. I've understood you to say that you want access to the negotiations and the documents and everything that went on in the lead up